recognizes Representative Moss.
Thank you, Mr. Speaker. This open and obvious doctrine was created by Michigan's Supreme Court in 2001, and it's used to bar certain ordinary negligence claims. Since its creation, it has been applied more and more broadly to the point that its application in many cases has become ridiculous. This doctrine requires the dismissal of any claim where the hazard that caused a person's injury was objectively visible or avoidable, and the circumstances of the actual case are not taken into account. And in one notable case, a claim was dismissed because the injured blind person failed to see and avoid the water that was on the floor. The use of open and obvious as an absolute bar has become so broad that even if you are blind, the circumstances of your injury are irrelevant. What chance does a sighted person have of trying to show that the hazard wasn't visible if even a blind person can't make that argument? My amendment would simply provide a narrower definition of the term open and obvious, allowing its use to determine the relative or comparative fault of both the injured party and the city that failed to make timely repairs to its sidewalk in the context of the circumstances for each individual case. This seems to me to be a fairer, saner way of looking at each side's responsibilities instead of broadening governmental immunity to the point where government entities can no longer be held accountable for ignoring problems with complaints about sidewalks. I hope for consideration of this amendment.
Thank you, Representative. The question before the House is on the adoption of the amendment. The clerk will open the board. The amendment is not adopted.